Okay, good morning, colleagues. Can we start? Welcome to our panel discussion, which will be focusing on one aspect of how international law applies to cyber operations. You can see the title there. It's about private contributions to cyberspace and international law perspective. My name is Dapo Akande. I am Professor of Public International Law at the University of Oxford and co-convener of something called the Oxford Process on International Law Protections in Cyberspace. Much of our lives as individuals is conducted online. A lot of our work, education, buying of goods and services, we do online. And of course, what's true for us as individuals is also true for us collectively. It's true for business, it's true for government. But as we've become dependent on, if you like, interconnected information and communications technologies, we have also become more vulnerable to threats that arise in that domain. And so one of the challenges, of course, that we face in global society is to think about how we can deal with some of these threats. We're very familiar with them from the newspapers, ransomware attacks on educational institutions, business, attacks on healthcare, misinformation, disinformation, things that fracture society, undermine democracy. And as lawyers, as international lawyers, one of our challenges is really to think about how does international law apply to these new technologies, and in particular, how does it apply in the cyber domain. Many of the threats that we see, or many of the issues that we see in this domain, relate to the conduct of private actors. And those issues relate not just to threats that come from private actors, but they also come from contributions, positive contributions, that private actors engage in to challenge and to deal with those threats. Sometimes private contributions responding to threats that are coming, in fact, from state actors. When we think about international law, very often we think about how it applies to the behavior of states. But international law is not just about state behavior. It's not just about regulating state behavior. It also applies to the conduct of private actors. And that is what this esteemed panel will be talking to us about. And we really do have a fantastic lineup of speakers to talk to us about an international law perspective in relation to private actors in cyberspace. So we have on this panel, if I start from my immediate left, we have Vasilka Sancin, who is Professor of International Law at the Department of International Law in the Faculty of Law at the University of Ljubljana. She has been a member of the United Nations Human Rights Committee and is on the Advisory Council to the Human Rights Council. Then we have Maral Kashgar, who is next to her. She is a legal advisor in the Office of the Minister of Defense of the Federal Ministry of Defense in Germany. Next, we have Kaja Ciglic. Kaja is Senior Director for Digital Diplomacy at Microsoft and from Slovenia here. Then we have Samit. Samit is a legal advisor at the International Committee of the Red Cross, where he's responsible for dealing with a whole range of issues to do with cyber and information technologies in the context of armed conflicts. And then last but not least, at the end, we have Duncan Hollis, who is professor at Temple University in Philadelphia in the US. He is also the co-faculty director of the Institute for Law, Innovation and Technology there. And together with me, he is co-convener of the Oxford Process for International Law Protections in cyberspace. So welcome to all of them, and thank you very much to all of you for being with us. Let me turn first to Kaja. In your role at Microsoft, you spend a lot of your time sort of working on how to strengthen international law rules as they apply to cyberspace. And maybe you can help us to set the scene and just begin by telling us, as a kind of general matter, what kind of trends that you're seeing in Microsoft in the cyber domain, in particular in relation to either threats from private actors or contributions that private actors are making to address these cyber threats. So let me start with that.
Thank you. Oh, thank you. And I feel very out-lawyered, I feel. But that's okay. I will try to give like a little bit of an overview. I think the main trends that we're seeing and sort of the main activity we've been seeing the last few years has just been an increase across the board of malicious activity in cyberspace. And I think that, whether it's from nation-state actors and actors associated, or from criminals, hacktivists, individuals, private groups, whatever you want to call it. So I think if I give you an example, Microsoft sort of defends against 4,000 attacks on our systems every second of every day. So the numbers are really high and it's sort of growing exponentially. The other example is, for a number of years we've been talking about, we track about 300 actors that are associated with sort of sophisticated attacks, often governments. I think that number in the last year has doubled. So the investments that states in particular are making in this space are increasing dramatically again. And the other thing that we're seeing is the merger a lot of the times between the sort of the government agencies and their associated sort of groups and the cyber criminal element. In the past, I think we've talked quite a lot about how, and the UN, I think, has had reports on it, on how the North Koreans in particular use cyber to effectively cyber crime to effectively fund their national cyber operations. So this is how they steal money and then they fund it. We've seen this trend move towards Iran has done a couple of attacks like that, the Russians as well. So I think the groups are kind of coming together and cooperating much more. And all of these attacks, all of the malicious activity is obviously driving greater awareness in sort of across the technology sector in terms of what our responsibilities are, what we should be doing as an industry to defend against them, and what does it mean. In sort of Ukraine, I think, was the first such example where it really clarified, or began to clarify, with help from organizations such as ICRC, that there's different rules. That and when if there's a war and not war, I think it's not something that private sector has really thought about, because a lot of the times it's just been they're just attacks and we need to defend. Has not necessarily been a focus there's been on what does it mean, whether whether it's IHL applies, international humanitarian law applies, what does it mean, what the rules are, and so it started to clarify. I think so. We'll see a little bit more of a understanding, conversation, and I think response, and particularly from the big tech actors in this space. The only other area that I would also highlight in sort of this initial remarks is the sort of the emergence of and that also again over the past 2-3 years really exploded, of what we called sort of the cyber mercenaries, which is the private sector offensive actors. So private companies that develop malicious software, or that they buy and sell vulnerabilities in products and services, and then sort of sell them on towards oftentimes governments to abuse as they please. I feel that the NSO, the spyware companies, the most prominent examples, but there's plenty of them. So I think that's another one just to keep in mind, sort of thinking about how international law and frameworks could help govern that type of behavior, I think would be helpful.
Great, thank you. Let me turn to you, Maral. You're legal advisor in a state, in a Ministry of Defense. And when we think about, as I was saying earlier, rules of international law, very often we tend to think about their application to states. But as Kaja has been saying, a lot of the activity that we see here aren't coming from states and coming from private actors. So to what extent does international law actually have anything to say about the conduct of private actors with respect to cyber operations and their activities in cyberspace?
Well, there is no sweeping answer to this question. So it is very important to differentiate a few questions. So first of all, it's important that we understand about whose cyber operations are we talking about. So is it involvement of private actors in a state cyber operation of any type? Are we talking about private cyber operations which a state just knows about and doesn't really control? So this is something that we need to have in mind. And also what is more important from my view is that we have to distinguish the types of cyber operations that we're talking about. When we're talking about cyber security or cyber defense, this is something different compared to offensive cyber operations. Because when we're talking about strengthening state or a cyber resilience of a state or defending against cyber attacks or malicious cyber activity, this has a different international relevance from a legal perspective than offensive cyber operations, where a state might involve private actors in order to harm the target, be it the adversary, the economy of another state. So we have to distinguish these types. So when we come back to cyber security and cyber defense, there we're talking about the involvement of private companies from a state perspective in order to protect the society, critical infrastructure and services, the own people. So this is a question of national security. And my question is actually, where is the need for international law to regulate this type of involvement of private actors? And whereas on the other hand, when it comes to offensive cyber operations, where private actors are involved in order to harm, there actually we have criminal law, we have international human rights law, or a law of armed conflict that applies, as Kaja just mentioned, where we still have to look at every single action on a case-by-case basis to identify which rules actually apply and which not. But where I see a gap is that private actors do actually not have human rights obligations. They can, because only states have these obligations, they can be translated into other different laws like criminal law and other types of legal regimes. And where we also have a gap is that usually private actors do not have jus ad bellum obligations. So the Charter of the United Nations, for instance, only applies to state conduct. But here, where we see gaps in regulating private acts, I think state obligations still can make up for this gap. For instance, a state cannot evade its own obligations for human rights law or jus ad bellum obligations by outsourcing parts of their cyber operations to private actors. So here, the state still has the duty to ensure respect for these rights. And also when it comes to jus ad bellum, we have due diligence. So a state is not allowed to let its territory or the infrastructure under its jurisdiction to be used to harm other states or other individuals. So these are questions that are relevant in order to identify which rules and international law does apply.
So sometimes you have international law applying to how the state regulates the private actor, and sometimes international law is applying directly to the conduct of the private actor itself. And maybe I can just come back to Kaja on that last point about how international law might apply, say, directly to the conduct of private actors. And just thinking about it from the perspective of Microsoft, to what extent is there some kind of willingness to have the conduct of corporate actors judged against these international law standards?
I don't think I can talk to for the industry as a whole, but I think Microsoft itself it's been very clear and it's committed to upholding these rules as much as we can. I think a lot of the times, like I said, the problem a lot is that the industry doesn't necessarily understand and follow the rule, not the rules, but the debate at all, right? And I think a lot of the countries even still don't really grapple with what these rules mean and how they would be applied in real world. I think the situation is even worse for a lot of the private sector companies. I think, like the bigger ones, like us, the Googles of the world, and probably have the resources, have a lot of lawyers and legal power to help navigate it. But a lot of the activity in cyberspace is fairly small companies, including from across of Europe. When you have a company that's maybe 100 people, I think unless it's sort of a compliance, like very clear, these are the rules that you need to follow, it's, I think, just hard for them to understand how they should act. So even if there is willingness, I think there's not always the capacity, I think I would say.
Let me turn to you, Samit, and from your perspective as a legal advisor at the International Committee of the Red Cross, and let's focus on situations of conflict. Kaja already mentioned how the situation in Ukraine has helped to focus some of the attention. So thinking about situations of armed conflict in particular, so two questions for you. So first of all, what kinds of contributions have we seen to cyber operations conducted by private actors, whether it's individuals, whether it's non-state armed groups, whether it's companies? So just give us a sense of just the kind of private contributions we see to cyber operations in the context of an armed conflict. And then second, and following on from that, give us a sense of what international law actually says about obligations that these private actors might have in situations of armed conflict.
Thank you so much for the questions, Dapo. So I'm very happy to go along the groupings that you mentioned, so individuals, what we call hacker groups, and then private technology companies. Before I do that, maybe I'll just preface by saying, the relationship between cyberspace and armed conflict is not that new, right? I mean, it's a relationship that's existed for decades, and a lot of it has been very positive. And this is a message that the ICRC, really tries to emphasize in all of our discussions on this issue, that connectivity has been extremely important for victims of armed conflict, for the capacity of family members to speak to, persons that might be displaced by armed conflict, for access to medical care or up-to-date information. It's been hugely important. So those are the positive aspects. There's also been, of course, negative aspects, and that's also existed for decades. So private actors engaging potentially in hacktivism or cyber operations. Of course, the use of social media for disinformation during armed conflict has been an issue. And so those negative aspects exist as well. Where I think the ICRC has really identified an issue that requires urgent concern is really the scale and the normalization that we've seen in the last few years on civilian involvement in cyber activities in armed conflict, because that's something that I think is qualitatively different over the last few years and in more recent armed conflicts. So starting with individuals. So I mean, individual civilians might become involved in cyber operations through, as I mentioned, hacktivism. They might do it on their own initiative, or they might be encouraged by a party to a conflict or a state to engage in such activities. They might be given tools, so potentially applications to be used either for, as I mentioned, hacktivism, or for, collecting military intelligence, which is something that we've seen. And of course, and this is true, across the different groupings, nothing in international humanitarian law prohibits directly the participation of civilians or private sector in armed conflict. However, there are risks that come with such participation. So something that we've seen is that sometimes, because of individual civilian participation, certain activities by civilians that normally would not be considered anything related to a conflict have led to direct targeting by a party to a conflict, because they've interpreted certain activities as direct participation in hostilities, even to the point of holding a cell phone, because potentially a party to a conflict might identify that, mostly wrongly, as gathering military intelligence or engaging in some activity against that's harmful to the party to a conflict. In terms of groups, so just in, let's say, 2 conflicts that have begun over the last couple of years, already over 250 different hacker groups have been identified participating in these 2 conflicts, which is a huge number. And much like individual civilians, oftentimes they don't know, the rules of IHL very well, or for whatever reason decide not to respect IHL, or don't think IHL applies specifically to them because it's something for parties to conflicts and not for hacker groups or for individuals. So that's a concern as well. And then with private technology companies, private technology companies have sometimes openly declared support for a party to a conflict, and sometimes implicitly supported one party against another in a situation of armed conflict. And here the concern is whether, for example, employees are aware that the ramifications of their participation, if they're aware that international humanitarian law applies, and then also the risks to the property of that company, so the digital infrastructure, the physical infrastructure, and then again, what are the repercussions on the civilian population that are end users of products and services from such private companies, many of them also in victims of armed conflict, or potentially might suffer as a result, physically on the ground from an armed conflict. In terms of obligations, very quickly,
just before you turn to the obligations, I was going to see if I could tempt you to give specific examples. So on the hacker groups, you mentioned 2 conflicts. I don't know if you're able to say which 2, or if you're able to give particular examples. If you can't, that's fine.
As a legal advisor for the ICRC, as you know quite well, Dapo, I won't speak of specific conflicts. I'm really sorry to do that, to be more theoretical, because indeed in my last job as an operational legal advisor, all I did was specifics, and now I will be more theoretical. But to be honest, I think it's relatively obvious. 2 conflicts that have been discussed quite a bit already at the BSF. So, I think I'll give you quite a lawyerly answer there. Yes, I hope that satisfies you. In terms of obligations, so of course, international humanitarian law applies to the acts of individuals, the acts of private actors, to hacker groups, and to employees of private technology companies. So that's clear. The vast majority of conduct of hostilities rules don't just apply to parties to conflict, even though, of course, there are a lot of IHL rules that only apply to parties. The vast majority of conduct hostilities rules and many other rules, also apply to individuals. Individuals can violate IHL, individuals can commit war crimes, and so this is a really important concern, because one thing that we've seen is the direct targeting of digital infrastructure, of the medical services, of critical infrastructure, as has already been mentioned, the direct targeting of the banking system, of social security, of our brother and sister organizations of the Red Cross and the Red Crescent that have been directly targeted, either because the rules are not clear or the relationship to a party is not clear, but these are humanitarian infrastructures that have been directly targeted, and IHL applies. But then I would be remiss if I didn't then also talk about the obligations of states. So these have already been mentioned, I think, from kind of a PIL or like a public international law perspective, but just specifically on international humanitarian law. Of course, if the acts of any private actor is attributable to a party to a conflict or to a state, well, then the state is, of course, responsible for those acts, responsible for those violations of international humanitarian law. The very first article of the Geneva Conventions, Common Article 1, says that states must respect and ensure respect for IHL. So certainly if parties to conflict, or if states are encouraging violations of IHL, even if they're not a party to a conflict, right? So any state anywhere in the world, if they're encouraging violations of IHL, this is itself a violation of international humanitarian law. And then finally, as has already been mentioned, it's states, of course, also have an obligation to suppress violations that are occurring on their territory. So there are many obligations also for states with respect to private actors' acts in armed conflicts. But I'll stop there.
Thanks, Samit. Having failed to tempt you to give specific examples of what the ICRC, maybe I can now turn to actually any guidance that the ICRC has. So what kind of work has the ICRC done on this issue? And what kind of guidance, if any, has the ICRC produced for this range of actors that you mentioned, individuals, non-state actors, corporation states, on these issues?
So I'm really happy you asked that question. Reflecting a bit the severity of this issue, the ICRC has been really scaling up its work on this topic over the last few years. So I think in maybe 2 minutes, I'll try to mention 6 different tools and guidance that we have, but I'll go quite quickly and happy to take any questions.
We're doing well for time.
Okay, very good. So the first one is, which has gained a lot of traction, I think, specifically with hacker groups, which is really great, is the somewhat well-known 8 rules for hackers. I always joke that it's a bit of a misnomer because, the 8 rules for hackers have been referred to as the ICRC rules for hackers or things like that. But really the 8 rules for hackers is a very simple restatement of some critical rules that apply to, what I mentioned before, that apply to all individuals. Anyone acting in cyberspace where where IHL applies, these 8 rules apply. So the rules are very simple. Don't target civilians. Don't engage in acts that are indiscriminate cyber attacks. Of course, IHL is based on non-reciprocity. So just because the adversary doesn't respect IHL doesn't mean that you no longer have an obligation to respect IHL. Of course, that you do. There's no relationship between IHL and LL.M, right? So even if there's a war of aggression, this doesn't mean that IHL obligations don't apply. So very simple, straightforward, IHL rules. This is something that's really gained a lot of traction, has been really helpful in kind of penetrating this hacker group community. So we've been really happy with that. Then second, there's the high level and a multi-stakeholder global advisory board that the president of the ICRC convened. The final report was released last year. Actually, Dapo, you were one of the members of the global advisory board.
And Kaja.
Tom.
Yeah.
But yeah, so I'm very happy if you want to contribute on the global advisory board final report. I think the report has been really helpful for the ICRC in sort of guiding our work on this topic because it was a multi-stakeholder initiative. It had private technology companies, academics, military, humanitarian organizations. So it was really helpful for us in guiding our work. And then it also provides, recommendations for private technology companies, for humanitarian actors, for belligerents, and for states who are really, hugely important sort of guidance document. Then we have, of course, the 2019 position paper that the ICRC published in the context of the work at the Open-Ended Working Group, which is, a group in New York, on establishing norms in cyberspace. And so the ICRC published a position on the application of IHL in cyberspace, which, of course, the ICRC recognized IHL applies in cyberspace. It provided our understanding of the definition of attack in cyberspace. It also explored the question of data and whether data is an object, and I think this is a hugely important question that we're really relying on states to publish positions on because it has such important ramifications for private actors as well. Especially private companies that provide, products and services, and, how IHL will continue to be relevant in protecting, ultimately, products and services that are to the benefit of the civilian population. So that is a really important document as well. Last year, the ICRC convened an expert meeting in Geneva in collaboration with the Geneva Academy of International Humanitarian Law and Human Rights in Geneva. This expert meeting also sought to kind of clarify some of the more technical legal questions that continue to persist, and then also kind of really lay out what are the questions that states and others and experts need to find answers for. So that final report should be published before the end of the year. And then I finally turn to 2 incredibly important initiatives that are coming up now on this topic. The first one is the International Conference of the Red Cross and the Red Crescent that will be between the 28th and 31st of October of this year. So the international conference takes place once every 4 years. The first one was in 1863, a year before the very first Geneva Convention was signed. It was the conference that adopted the distinctive emblem. So, I mean, I can't underscore how important this conference is. It brings together, of course, all the states of the world that are party to the Geneva Conventions. And as I've kind of alluded to, the question of IHL applicability in cyberspace has kind of taken different forms all over the world. I mentioned already New York, and of course several states have national positions, and there's different forums all over the world. But this is really an opportunity for the first time since many of these very important conflicts have broken out. It's the first time to really bring this question home. To Geneva, where international humanitarian law was conceived. And it's really an opportunity to bring together every state, but it's also an opportunity to bring together the national societies of the Red Cross and the Red Crescent. And the national societies, of course, are at the forefront of assisting and protecting victims of armed conflict on the ground. So they have incredible expertise and need to be part of this conversation, and it's really the first time they'll be part of this conversation. And the ICRC is proposing a resolution on digital threats and protecting victims of armed conflict, civilians, and other persons that are protected under IHL. So we really hope that states can come together and not create law with the resolution, but come to certain common understandings that for us are self-evident in terms of how IHL applies. And then very quickly, in 30 seconds, I'll just mention the Digital Emblem Project. So this is a project we've been working on over the last 4 years, more or less, since 2020. Basically, in international humanitarian law, the medical services and certain humanitarian operations need to be respected and protected. That is the purpose of the protective emblem, right, of the Red Cross, Crescent, and Crystal. That's why it's put on transports, on buildings, on units, on individuals. There is no way to reflect that signaling in cyberspace. And so the purpose of the Digital Emblem Project is to have a way to signal this specific protection to cyber operators. So this is a multi-stakeholder initiative, and I always like to end with this because it's a really positive project, right? It's a way that the private sector can positively contribute, actually, to ensuring that civilians, the medical services, humanitarian operations are respected and protected. So a hugely important project. Microsoft has been, of course, very helpful with the project and sort of navigating some of the technical nuances that we are not necessarily, the ICRC is not necessarily experts on. So very important project. It also figures in the resolution, the support for the Digital Emblem Project. So I'll stop there.
Okay. Thank you. Let me turn to Vasilka, and let's turn to human rights law. Maral already mentioned the importance of human rights. So much of this activity, at least certainly in terms of threats, has an impact on human rights of individuals. The question that's then raised, of course, is to what extent do private actors have human rights obligations, or to what extent do states have an obligation somehow to protect the human rights of individuals? You, of course, were on the UN Human Rights Committee, so who better to turn to on those questions? What role does human rights law play here?
Indeed. I think at the outset first I have to apologize because we don't have this beautiful digital background accompanied by BSF Symphonic Orchestra to keep you engaged in this discussion, and I know it's a very technical one, so I'll try to deliver my message in a, let's say, simplified form, and apologies again for that to those who are experts on the issue. First thing I think that needs to be recognized is that human rights apply at all times, times of peace, times of armed conflict, and both online and offline. So I think this is a very important consensus that exists in the international community, that also when we are operating, let's say, in a cyberspace, all the human rights law applies. Now, it is true that the primary focus of international human rights law have always been states, with their obligations to respect, protect, and fulfill human rights of individuals within their jurisdiction. And there is already one challenge, I would say, for implementation of the state's human rights obligations when it comes to the interpretation of this notion of what falls within the state jurisdiction. Because also activities that take place outside of their territories or even outside of their direct and effective control might fall within their human rights obligations, as we have seen now these developments both in the UN Human Rights Committee as well as the European Court of Human Rights. Now, private actors, of course, are crucial to implement all kinds of activities, and they're also at the forefront of technological developments. They drive the development of new technologies, including artificial intelligence and so on. So what good is international law if it remains just written on the paper? It has to be actually implemented in practice. And this is where, of course, we see all this involvement of private actors. And one important development that I think we can observe in this respect is that states are trying to figure out how to provide at least some normative framework for the behavior of private actors, including companies, which has evolved through soft law instruments such as UN Guiding Principles on Business and Human Rights, and other such similar initiatives. But also now, if we are observing what is happening within the European Union context, for example, adopting a directive, EU directive, on corporate sustainability due diligence. They are trying to bring their own state obligations, because states have due diligence to ensure that individuals' rights are not violated also by private actors. They are trying to legislate, let's say, this into some normative, some legal framework that will be in effect in a few years from now, also for companies. So companies will have this due diligence obligation, of course large companies, but also their partners and down the supply chain will have now this legal obligation stemming from this directive to introduce due diligence impacts assessments and identify risks, mitigate, remedy if necessary, provide access to the remedy for affected individuals. And the states will be conducting an oversight of how these obligations, how these responsibilities are being complied with. So what, in my view, is very important now to consider in terms of how international law is being implemented and enforced, because as I said, it's not worth much, as we can see in the developments across the globe, if it is not respected, is to try to see if it is possible to create space for closer partnerships between states and private actors to identify the best, I would say, mechanisms or perhaps ways to implement these private actors' obligations. Because otherwise we will end up in a very fragmented situation where companies obviously will be interpreting their obligations in their own ways, and then states will also be exercising oversight very differently from one state to another or from one region to another. What we need to come to at the end, I would say, is to level the playing field, to introduce some harmonized common standards for private actors how to implement and ensure oversight over this due diligence obligation that is now being not only, let's say, introduced in terms of recommendations that various UN bodies are issuing to states on how to influence their behavior of their private actors, but also in terms of legal obligations. And if we add to this not only due diligence obligations stemming from, let's say, this corporate sustainability due diligence directive, also the Artificial Intelligence Act adopted recently by the European Union, which is based on risk assessment concept, we will see that there will be a very strong need to interpret for the private actors to understand what is expected of them and to have the same expectations for private actors regardless of where they operate on our planet. Thank you.
Thank you. Kaja, I keep coming back to you just because you are the sole representative of somebody from what we might call a private actor in that broad sense in which we're using this term. Any response to these developments that Vasilka has just been mentioning from your perspective?
No, I mean, I would probably, does this work? Okay. Sorry. No, I would agree completely. And I think that is to be honest, I think that is the only way forward, in particular in a world where you have actors who, I mean, cyberspace is by definition across borders, right? I think there are some countries that are very, like China or Russia, obviously it's a very closed environment. But beyond that, with significant impacts for human rights. But across the rest of the world, the technology more or less operates irrespective of where the national border lies. And I think there's challenges in that for the private sector. I think in some of it, Vasilka just referred to sort of the individual interpretation, whether it's human rights obligation, whether it's cybersecurity obligations, or sort of AI rules, or things like the data protection obligations. I think if the biggest challenge oftentimes for the companies is if they vary too significantly from one country to another, because then, and in particular if the rules are in conflict. If sort of country A says you should do this, country B says you should do this, then a lot of the economies of scale just don't work because you cannot do it. And oftentimes, I think this in particular in the cybercrime context, you have law enforcement agency wants a particular data from, in country A, wants data from country C, but the rules are different, and sort of the companies tend to be then stuck in the middle and being like, you need to talk to each other. We can't really resolve this issue for you. So I think if there's focused on sort of working across borders and actually not necessarily leveling the playing field, but actually raising the playing field, I feel like for human rights and for cybersecurity, I think the vast majority of the companies would welcome it. And like we've seen, but then you can come into conversations like we've seen with the recent UN negotiations on the Cybercrime Convention. I think you have very different perspectives coming together from across the world, and the end result might not be always in sort of what a strong human rights advocate would want to see. Same, for us, I feel the cybercrime treaty that was adopted, took some, it could be, some of the human rights protections in particular could be stronger. And I think we advocated strongly in partnership with actually civil society on things like that. So, but if you want to have a global framework, I think those are the discussions you have to have. And I think it's also important that it's not just sort of the EU that moves forward or the US that moves forward, but actually brings people along to sort of raise the field for everybody.
Duncan, on the other side of the room, but I haven't forgotten about you. So finally coming to you. I mean, international law can only do any of the things that we've talked about if we actually know what international law is and if we have some clarity as to what the rules are. And one of the things that we've seen in recent years is states actually coming out and giving their own views as to what international law says, so issuing these sort of national position papers. What are the trends that we're seeing in relation to states seeking to clarify what international law says?
Thanks, Dapo. And actually, apropos of our panel, let me step back and say, I think it's been a synergistic story, right? So I'm going to focus on the national statements, but I don't want to suggest that it has been in the absence of private contributions. Indeed, beyond industry, academics and entities like the ICRC have long been making efforts to clarify what international law means in the cyber context. I mean, albeit Russia may have been the first that opened the door in 1998 by proposing an information security treaty, but since then, it's been the ICRC issuing statements on international law. It's been the work of the independent group of experts under the Tallinn Manual that have issued 2 books on cyber warfare and cyber operations. It's the International Law Cyber Toolkit, maybe some small contributions from the Oxford process that have, in some sense, operate alongside and maybe catalyzed states. If suddenly, if all these private actors are saying what international law is and states disagree, they felt they need to speak out. And so it's actually, I think it's a dozen years ago this month that then legal advisor for the US State Department, Harold Koh, actually made kind of an official speech about international law applies in cyberspace, states are responsible for their behavior there, and both the prohibition on the use of force and international humanitarian law apply. And it was kind of remarkable that a state had made a general statement of this kind. It wasn't about a specific case or incident. It wasn't in the form of some international organization negotiation. It took a few years, but then other states began to follow. So 2015, Germany's cyber ambassador talks a bit in an official capacity about this. 2018, the UK's Attorney General gives us a talk that I think was most notable for suggesting that the rules of territorial sovereignty we have that make it unlawful if, say, a balloon crosses into your airspace that is from another government or planes or what have you, that had not necessarily matured into a cyber equivalent. Other states then started to speak out and kind of express different views on this: Estonia, the Netherlands, Australia. The work of the OAS, which I had some affiliation with, and then the UN group of governmental experts then began to call on states, and we've gotten more, everyone from Guyana to Japan to Brazil have opined in recent years, and we're starting to see even more. So I think Costa Rica and I think Austria is the last one to put out. So there are now, by my count, 38 governments have issued official views of their government on the application of international law in cyberspace. And in March, the African Union issued a common position on the application of international law in cyberspace. So there's been this trend, and then I guess you say, well, what's the significance of it? And I'd break it into, I think at least for me, it's three questions, and maybe again this is where private contributions can come, because while states are busy trying to figure out what their positions are, we can step back as academics or researchers and say, what's going on here? And I'd flag, I think there are issues of novelty, function, or functionality, and efficiency. So novelty, the first question is, are these statements new in some way, or is this just part of diplomacy as it's existed for centuries? Second, functionality, what is it that these national statements are doing, right? It's one thing when they were just kind of one-pagers, quick things, but like if you go look at Austria or Costa Rica's position papers, they're footnotes, they're 18 pages, some of them are giving hypotheticals, makes a law professor proud. And then third, in terms of efficiency, is are they doing anything, what are they doing to clarify international law, let alone make cyberspace safer, secure, more rights respecting? And I don't know that I have the answers, but I'd say on the novelty front, I think what's kind of interesting about these statements is in the past, states have long said things about what they think international law means, but they tend to do it in the context of a particular crisis or controversy. So the US invades Iraq in 2003, Russia invades Ukraine in 2022, lots of individualized statements or views on that conflict or that event. Where you tend to get more generic, what does international law mean, has been more in places like the United Nations, General Assembly resolutions on the new international economic order, like what is the law for expropriation. But you haven't seen states, I think, in this way coming out and trying to say, this is how we understand international law holistically. So I think there's something new here, and it may have to do with the nature of cyber operations, right? Where states, when they operate, are always doing so in a secret and covert way, so they don't actually acknowledge their cyber operations, or they do so only very, very rarely. And very interestingly, when they attribute a cyber operation into another state, when it's China attributing to the US or the US attributing to Iran, they talk about it being, unwanted, unfriendly, but they don't actually talk about international law. So where we're looking for the clarifications of international law, all we really have is these national statements. So then functionally, what are these statements doing? And here, there's a bunch of existing sources of international law, and we can try and map these statements onto those sources. One is sometimes states, when they unilaterally speak, we have a concept of unilateral declarations that can bind the state. The problem, I think, is they require either some clear indication of intent to be bound or creating reliance expectations. And I'm not sure, as much as I value states having made these national statements, and feel free if there's legal advisors in the room who want to disagree, I don't think there's either that intentionality here or necessarily yet the reliance expectations. So I think we put that aside. Then there's customary international law, right? Law that's state practice plus what we call opinio juris, right? That it is subjectively accepted as law. And I also don't know that we can say these statements yet have reached a point where we can say they are constituting customary international law, because it usually needs to be both general state practice and uniform state practice. And as much as 38 national statements is an important trend to watch, it's not 190 plus, right? In fact, the vast majority of states have yet to speak on this issue. So it's hard to say that we can look to these statements alone as evidence. And then in terms of the uniformity, some might disagree, but actually it's been interesting to see that states will say some things about, say, due diligence, the positive obligations of states to take care and do things to make sure that international laws and human rights are obeyed in cyberspace. Some states think that due diligence applies to cyber operations. Others have kind of put question marks around it. So we actually have some divergence among the 38 states that have issued statements. And then last, and I'll close here on the efficacy point, I think it kind of remains to be seen what these statements are saying. So one could be critical and say, wow, 38 statements, but there sure are more Japan, US, Canada, UK, France issuing statements than kind of the brief views of a Guyana, let alone a number of other global South states. And what does that say about the construction of international law? Is it privileging certain voices, the ones who have the most resources and capacity, over others? And also, is this supplanting the usual form of international relations, right? The usual where states would say, hey, we think what you're doing in that cyber operation is a violation of international law, specifically this IHL principle or this rule of human rights. Like, in some ways, the national statements are a substitute for that. And they're also a substitute for doing what states often do with global problems, right? Either General Assembly resolutions or regional international organization efforts or a treaty. And so there's actually kind of a looming question of whether there will be a cybersecurity treaty of some point. So that's the negative. The one thing that I would say, and kind of an ending a la Samit on a positive note, is there is this really interesting potential here in the world of AI that suddenly, with the internet, states have the ability to make their views known, and 190 states could do so. And we now have generative technology that can take the views of those 190 states and tell us where the commonalities are, right? And I don't know that we're there yet, and there may be real risks in doing so, but whereas customary international law used to be, you'd go pull out the treatise, and you'd say, oh, here's an example from France, Canada, and Russia, and that's customary international law. Now we have a chance to actually maybe have a little more sovereign equality with these statements. So I do think it's an interesting space to watch.
Thanks, Duncan. Let me come back to you, Maral, because you are the one state representative on the panel, and to have your reflections on the points that Duncan has just been making about the way in which states are seeking to clarify the application of the rules here. Do you have any responses to the questions he's raised?
Well, thank you. Very interesting question and interesting remarks, because to be very honest, to formulate a national position paper is something very new, at least it was for us, very new to do. And it forced us for the first time to get deep into the law, to realize what are our positions actually. And it's one thing to say it's difficult to find common positions between states, but it is as difficult to find a common position within one state. So it was very interesting for us to see the interagency cooperation on working on this national position paper, particularly from a perspective of the MOD. Because most of the countries who have published their position papers, they are mostly written by their MFAs, but MFAs usually are provider of the law, where the MODs or the armed forces or any other national security agency is the demander of the law. We apply the law. So when we look at our national position papers, from our perspective, the security agencies, it was very important to keep our flexibility. So they are very, at least our position paper, I think we have 20 or 17 pages, so it's pretty long, a lot of wording in there, but still our concern was to keep it flexible enough, general enough, so that we can still operate, still protect the country. And as we don't know with new technologies what will come tomorrow, we have to be very cautious in formulating. But nevertheless, it was very important from a German perspective at least to contribute to, in general terms, what international law actually says in a new technology in the cyber domain, which is new. And so what I want to take away from this is new, and also new for a state to really deal with these issues that we not always had to do before. So, and this is something which is very, very fruitful and necessary that we do, but still it's just a first step, because what we really need from a national perspective is to operationalize our national position papers. So this is important from someone who was legal advisor to national cyber operations. What does it mean, sovereignty? What does due diligence mean? What do the IHL obligations actually mean in a very, very concrete situation? So we have to further deepen our thoughts on what we have written in our position papers.
Well, thank you very much to the five of you for those engaging answers. Now to turn to the audience. Just as I hadn't forgotten about Duncan, I haven't forgotten about you. So if we can have questions, maybe I'll gather a few. I'm very conscious of the fact that it's a mixed audience. Some of you are international lawyers specialized in this. Others are people who are not lawyers. So if we take that into account as we ask the question. So I'll gather a couple, and if you can maybe say who you are as you ask the question. So yeah, first Kubo.
Thank you, and thank you to all the panelists for a fascinating, very interesting panel. Just a brief follow-up on this demand for practical examples. So the project that Duncan kindly mentioned. Oh, I didn't introduce myself. I failed already at my first task. So my name is Kubo Mačák. I'm a professor of public international law at the University of Exeter in the UK. So just thank you, Duncan, for mentioning the Cyber Law Toolkit, which is a project we lead at the University of Exeter. It has quite a lot of exactly these practical examples in our scenarios about sovereignty, non-intervention, what it means in practical terms. So I think a lot of practitioners reach for that, for some of the examples. My questions are not about national positions, for a change as well, but I would ask Mara, you back a question about cyber defense. So something that struck me about your point that you made towards the beginning of your first contribution was that when it comes to cyber defense, the role for international law is quite limited. So I wanted to throw it back to you with a question about active cyber defense. So when states are engaging in networks outside of their jurisdiction in order to protect themselves, sometimes only to monitor, but some of the states have said publicly that they do this in order to produce effects also outside of their own territory, outside of their own jurisdiction. Do you think there might be a role for international law, and what is the thinking of the MOD on that? And then maybe a broader question to all of the panelists. I was wondering, one thing, we're talking about private contributions to cyber operations. One thing I think we didn't explore too much yet is about the geographical aspects of private contributions coming from outside of the site where they produce their effects. So for example, in ongoing armed conflicts, and I completely understand, Samit, why you wouldn't mention specific ones, but even if we think of a hypothetical international armed conflict, and we would have a private contribution from outside of the site of that conflict to one of the parties producing effects there. What is your thinking on that? Even if they fully comply with IHL, is there a role, for example, for the law of neutrality? Are there other limitations that we need to look at when it comes to these actors? And sometimes the motivations can be very noble. You can imagine private hackers from another country being very upset about something they perceive as aggression, or they might launch cyber operations against the Ministry of Interior that's suspected of committing torture against people in its own territory. So we might understand that the motivations might be quite noble, but I was wondering, what are your perspectives about what international tells us about where the limits lie for such contributions that go across territorial boundaries? Thank you.
Okay, thank you. Why don't we start with that question, and maybe we start with Maral for the first question, and then for the second one, a number of you might want to opine. I'm sure Samit, maybe Vasilka, but we'll start with Maral.
Thank you for this question. Actually, I didn't say that when it comes to cyber defense, international law has a limited role. But I posed the question where the role of international law is here, because what I wanted to highlight is the difference. The intention behind cyber defense is a completely different one than from offensive cyber operations, first. Second, we must be very cautious in drawing clear lines between cyber defense and defensive cyber operations and offensive cyber operations, because it is still very unclear where the lines really go here. But whenever we have a cross-border effect, so that a state's own actions or a private actor's actions attributable to it, or anyhow the involvement of a private actor affects the rights of another state or other individuals, their state responsibility comes in. The degree depends on the case. But yes, there is obviously a role for international law that comes in. So even for cybersecurity, where you have only passive protective measures strengthening a state's cyber resilience, even there, international law has a role. For instance, European law, we have a lot of regulations right now. For instance, the Cyber Resilience Act or NIS2, obliging private companies to contribute to cybersecurity in nations. So this is part of international law as well. So, but we have to, what I wanted to make clear is that we need to distinguish when we look at cyber operations and the involvement of private actors, what type of cyber operations are we talking about? So this is very, very important to identify what laws we need and what international law actually regulates here.
So the second part of the question, as I understood it, was to get us to think about cases where you've got private cyber operations that cross boundaries, and what might international law have to say about that? Maybe, Samit, if I start with you.
I'm really happy to come in on that, and thank you so much for the question, Kubo. And for the record, Kubo's being really humble in introducing himself. He's had a hugely important role on this topic, also with the Cyber Law Toolkit, also in assisting states in developing national positions. And for some reason, Kubo works at ICRC and was asked to fill in his very big shoes for some of his files, and I notably have smaller feet than you, but trying my best. So yeah, I mean, for international humanitarian law, of course, anytime an act has a nexus to an armed conflict, IHL applies. So it doesn't matter, where the person is located. If there is a nexus to an international if there's an act that has a nexus to an international armed conflict, I mean, IHL applies to that act. And I think that there's this issue of knowledge. That maybe, because persons have, let's say, as you said, good intentions, or they don't necessarily see what they're doing as a violation of the law, it is important that they know, what IHL is, why there are these obligations, why there are limits. Even if a certain state is engaging in an act of aggression, why you cannot target the banking system, or you can't target the civilian aspects even of the government, and who ultimately is harmed by such activities. And that knowledge is lacking. And that brings me to something that I'm a bit pedantic about, because I know it's easy to say, and actually it also figures in the final report of the group of governmental experts, where the only place where IHL is kind of sort of mentioned, but it's often said that IHL only applies during armed conflict. This is, of course, incorrect. IHL doesn't only apply during armed conflict. IHL applies only to armed conflict. And of course, conduct hostilities rules, related to hostilities, obviously by its name, applies during armed conflict. But there are also many rules that apply at all times. And so I already mentioned one of them. I mentioned Common Article 1, is that states have to respect and ensure respect for IHL at all times. It's not limited only to when they are a party to an armed conflict, or when their territory there's hostilities in their territory. There's also the obligation to disseminate IHL, right? So I think that this is a really important obligation in this respect, especially when there are, potentially hacker groups or individual, hacktivists that are engaging in operations cross-border in another state. It is important for the state to make clear, in such situations, to disseminate IHL to their armed forces, and then also more broadly to the civilian population, particularly when their civilian population is engaged in such activities. What is IHL? How does it apply? What are the limits? So I think it's important to keep in mind, again, the obligation of states in that respect.
Okay, we are running out of time, but Vasilka?
Yeah, very quickly to add to that, I think it's very important to observe the development of the understanding of the notion of the jurisdiction, as I mentioned before. Because I think that while states have traditionally been, let's say, concerned about potential claims for what is happening on their territories, they are now increasingly paying attention to what is also happening well beyond their borders. Because even if, let's say, certain surveillance activities of states would affect individuals in countries, and these individuals have no other link with the state that is conducting or private company that is conducting surveillance operations, but then the data is being used by the state, these individuals would have a valid claim against the state. And they are becoming increasingly more successful in various fora because contrary to IHL, where perhaps the states collectively discuss it every 4 years at the Red Cross conferences, human rights law is being daily discussed in various global as well as regional fora. And there we can see a lot of development now connected to cyber operations where we see the empowerment also of individuals to come with their allegations, let's say, of human rights violations against states in various fora for activities that would traditionally never be considered as raising any responsibility of the state. But nowadays, because of the, let's say, borderless cyberspace, there is a new trend, and I think that the states are paying a lot of attention to this, as well as private companies, because also their actions will be impacted on the decisions on these individuals' claims.
Let me take a couple more questions. So I'll take 2 questions together. I'll start with you, Marguerite, and then from this side as well. So if I start, first of all, on that side, if you just introduce yourself, and then, yeah.
Yeah, Marguerite Walter. I'm an attorney advisor with the U.S. Department of State, so bringing the MFA perspective. And it's more of a comment than a question, following up on some things that folks were saying about the national statements and what they mean and what they are. I do think they're a little bit different from the way that international law has traditionally developed. They're more political statements. They're not making a claim. They're not applying the law to a specific set of circumstances. So I guess I question to what extent they themselves would contribute to the development of custom. And I don't think that they're substituting for claims. I think this is often a source of frustration that I hear from academics and others, that states never mention international law when they're attributing. I think there are a lot of reasons for that, one of which is the need to make an attribution statement quickly, and legal analysis never goes as quickly as you want it to. But maybe also what we're seeing is not necessarily yet crossing clear legal thresholds. And I note, for example, I think it was Kaja was talking about states working, coordinating increasingly maybe with cyber criminals. Well, it's not always easy to figure out when the state's responsibility is implicated when you have private actors. And we see, I think, some states exploiting that. So I think watch this space for more claims. I'm sure they will come, and that will help us clarify the law a little bit more.
Thank you. Yes.
My name is Jana Borzikova. I'm part of the Young Bled Strategic Forum. And during our sessions, during our program, we had a conversation with Commissioner for Human Rights, with Mr. Michael O'Flaherty. And I would like to turn back in my question a bit to the human rights aspect and ask you, especially maybe Ms. Sancin, about what would you like to see from such a powerful institution such as Council for Europe, when it comes to human rights, and especially when it comes to the horizontal aspect, which increases its importance nowadays. Thank you.
So we'll take Marguerite's question her statement as a comment, and then if I can ask Vasilka to respond to that last question.
Yes, thank you. Personally, I am not a fan of legislating, let's say, to adopt a new convention for every new concern that the states might have. But as I said, there is a need for interpretation that would be harmonized across different states and then consequently also duly applied. The Council of Europe, as you know, recently adopted a convention that will deal also with new technologies and artificial intelligence. And I think the states now will have an opportunity to really start implementing, once they become parties to this convention, adopting the necessary domestic normative framework, the oversight mechanisms for compliance. And this is where I think it's important to foster these multi-stakeholder dialogues with private actors and states to effectively enforce or implement, let's say, these obligations that I don't think need to be changed. I think the human rights law that we have today is very well developed, and there's little need for adding new rights, although there's a lot of discussion of adding a new right, new digital rights, neuro rights, all connected to also new technologies in cyberspace. But more than that, I think there is a need for adequate implementation and oversight and providing access for effective remedies.
Okay, thank you very much. I think we've run out of time. It's nearly 11:45. I know there are a number of people who still wanted to ask questions. They're looking at me with those eyes thinking, can you please take my question? But I have the coordinator of the room also looking at me thinking, don't take that question. we need to finish. But just to wrap up, I was thinking, our panel is on private contributions to cyber operations. And in a sense, what I take from our discussion about the role that international law plays is, in terms of, first of all, the landscape, we have three ways, in a sense, in which private actors are relevant. So first of all, private actors may be relevant because they are the ones posing the threats. And international law might have something to say about the private actor posing the threat. Secondly, private actors might be relevant because they are making a contribution to countering a threat. And by doing that, making a contribution to countering a threat, they may, in some way, actually become subject to certain rules of international law, particularly in the context of international humanitarian law. They may be taking a direct part in hostilities, and they open themselves up in that way. And then, of course, private actors are relevant in the sense that they are victims of these threats that we're talking about. And so we talked about human rights law. Of course, private actors might be violating human rights, but private actors, as we've just been talking about, are often the victims of those violations, and they may be seeking to make a claim or to have, in some sense, their human rights obligations enforced. And international law has something to say across all of these areas. But of course, one of the things that we need to do is, first of all, to clarify what international law has to say, and that's a challenge that we all face and in which we can all contribute. What does international law say? And then, of course, there are the questions of developing mechanisms by which we can enforce those rules of international law. It's a continuing struggle across all of those fronts. But thank you so much to the panelists for enlightening us with their responses, and thank you to the audience as well. If you can join me in giving them a round of applause.